Hello everyone, welcome to this episode of our property investing channel when we bring you real actionable tips and strategies to help you maximize your profit and reduce your risk in your property investing journey. This is your host Amir Sahat, and today we're gonna be talking about the importance of legal due diligence when purchasing a property. To do it in the right time and with the right expert to prevent unnecessary risks, stress and frustration in future. To help us explore this topic, I have invited Melissa Barlas, Director of Proptech Legal, who is an experienced conveyancing lawyer. So without further ado, I'd like to welcome Melissa to our show. Melissa, thank you very much for being here.
Thank you for having me, Amir.
It's my pleasure. So just before we talk about serious things, just tell us a bit about yourself, your experience, and your journey.
Yes, thank you. So my journey in the property law space started roughly around 10 years ago when I was starting out doing a Juris Doctor of Laws at Monash University. So second year in, I got my first job working for a property lawyer and his wife, who were both property lawyers, and then started my journey from there on, gaining a lot of experience in the conveyancing space, amongst other areas, related property law areas. And then conveyancing was a very strong focus in my core work over those years, and made the decision when I was in private practice at another firm around early 2021. I made the decision to go out on my own and effectively work for myself from July 2021 onwards. So it's been about a year and a half kind of journey since doing that, and I haven't looked back since. It's been fantastic.
Absolutely, absolutely. So tell us a bit about conveyancing and its process, basically. How does it work in general?
Yes, you can't assume everyone knows exactly what that means. So it's a good question to start off with. So conveyancing is the term to describe effectively preparing for the transfer of a property from one person to another. So my role as a property lawyer that specialises in conveyancing, I would represent either a buyer or a seller in the legal process that needs to be followed through to transfer the property. And I effectively perform all of that legwork for the client to ensure that the property is transferred successfully.
Absolutely.
And
And
the overarching term to describe that process is conveyancing.
absolutely. And especially with all those legal jargons that most of us don't know. You are a
Yes.
person who needs to, have a
Thank
look
you.
at all those legal documents so you can give us a proper advice for sure.
Correct. Yes.
So how different it is in different states?
Vastly. So I specialise in the Victorian state when it comes to conveyancing, but every state has their own process when it comes to preparing for property settlements and conducting the conveyancing process. So it's not uniform. It'd be nice if it was, but every state is fairly different. For example, WA might just have simply a settlement agent that goes out and does the settlements, whereas New South Wales and Victoria, there's a lot more involved in the process as compared to other states.
Sure. We have Section 32 in Victoria, which is,
Yes,
something that we only have, and it is a very important document. So
correct.
just tell us why contract review is so important and what are the risk of not doing it before signing a contract?
Yes, so very good question. When it comes to contract reviews, one thing to emphasize is the importance of why it should be done. And then the other thing to emphasize is the timing at which it should be done. It's the
Absolutely.
timing that's just as important. So the reason why we do it is because we by having a solicitor such as myself reviewing your contract and your Section 32, we're able to identify whether there's any red flags associated with the property that's being disclosed in the Section 32 that we think you need to know about, because that can inform your decision on whether you actually buy the property and if it meets your specific needs or if it's going to cause more problems than not. And we also identify any red flags associated with the terms and conditions of the contract. So the contract might have onerous conditions that might not suit you as a buyer, that might be against your best interests as a buyer. And we come in to effectively try and ensure that the contract contains a nice balance in terms of obligations and rights between you and the seller. So that in a nutshell explains why it's so important. And effectively, if I summarize that further, you're managing your risk. We do it as a safety net for you to properly manage your risk so that you're buying safely. It's all about buying safely. And then the second component that I mentioned at the beginning is the timing. And the best time to get that contract review done is before you buy a property. It's worth acknowledging that when you are buying, sometimes time is of the essence. You might be competing against other buyers and you don't have much time to get the contract reviewed. So that's why you need to work with a solicitor such as myself to make sure that the contract is reviewed as soon as possible, which is what we do for our clients. But the best time to do it is before you buy, just to ensure that, like I said before, you're buying safely. But also, if you review the contract after you buy,
there is no point basically.
We then have to deal with a situation about terminating the contract, which can incur additional legal expense. It's an extra stress that you would have to deal with trying to back out of a contract versus if you just knew in advance of buying something, whether there's red flags or not. It's a much better outcome for you if you needed to walk away, easier outcome. So they're probably the key reasons for why I would suggest having the review done before you buy.
And there is a very fine line between engaging a conveyancing lawyer too early or just, too late in the process, because I've seen some purchaser that they engage conveyancer in a very late stage. And basically they just said, we like this property, we signed it, and right now it's time to engage a conveyancing lawyer, which is basically too late. After you sign the document, you're liable for that contract, which put lots of risk on you. And if there is any red flags that you mention is in that contract, the risk is with the purchaser. So definitely before signing that contract, a person with an experience, legal due diligence, correct due diligence system has to review it. But engaging in conveyancing lawyer too early in the process, let's say you want to have an inspection on Saturday and you haven't seen the property yet, you don't know anything about the property, and you're sending that document to your conveyancing lawyer and just saying, just check this for me, please. It just puts a lot of unnecessary work on your conveyancing lawyer, I believe. And, it also costs you more. So there should be a fine balance between inspection and, knowing that you want that property. And then before doing anything else, as part of your due diligence system, engage a conveyancing lawyer.
Yeah, that's right. And if I can add to that, as a solicitor, it's important for me to just be as commercially minded as my client. So yes, engaging me too early could result in, it's not the best, because in terms of exact timing for when you should engage your conveyancing lawyer is when you've narrowed down on a property that you like, you've, you may present an offer to the agent, whether it's, an email, text message, phone, whichever way, so long as it doesn't involve actually signing the contract. But you would present the offer, and then if you receive feedback from the agent or the vendor to say that they may be willing to entertain your offer, it is the perfect time to engage me at that point, because at least you're in with a chance to get the property. You're not incurring further legal expense on getting one contract reviewed over another. And I tell my clients that, because I genuinely believe that, I want to do right by them, but also I don't want them to rack up unnecessarily legal costs if I can help it in some way.
Absolutely.
So best time to engage is if you've got an idea that from the agent that the vendor's willing to entertain your offer, or you're within their target, to give you a better chance of actually winning that property, securing that property, send me the contract and the Section 32.
Absolutely.
You
mentioned about red flags and risk, and this is all this interview about. So we would love to hear about these red flags and the risks. So I think red flags are different for each investor according to the situation, according to their investing objective, and at the end of the day, what they are going to achieve from their investment. For instance, a person who wants to buy an investment property with the plan of subdividing in future has to look at different legal terms compared to a person who wants just to buy a house to live in and enjoy, living there. And that is the main purpose. So tell us about things like easements, covenants, zoning laws, rates, levies, work performed on the property legally or illegally, things that people who want to invest or even, just to buy something as their dream house need to consider before basically proceeding with that purchase.
Yeah, so the advice is always going to be different to a client, whether, like you say, whether they're wanting to invest in something to knock down an old property and then rebuild to 2 units, versus someone that might just want to find something as a long-term home for them and their family. So if I give you a few scenarios, covenants against the title, which are effectively restrictions that run with the land to bind you and all future owners, are something that are incredibly important and that we need to really critique and advise about if you are ever wanting to subdivide, or if you're ever wanting to develop on a property, because sometimes those covenants will have bars against you doing things that you want to do. And I've seen time and time again where, you've got a land lot that it might be sizable enough to ordinarily put a development on it, or 3 lots or something, but there's a clear covenant that says you can only have 1 dwelling house on the property.
Absolutely.
And then the process of getting that removed is a long one. You may need to go to the Supreme Court and whatnot. So then you need to weigh up the cost versus benefit of, is it worth my time to acquire this property, or should I move on? Easements on a practical level, they're important in terms of how far you can build back or to the boundary based on the location of the easements, because you need to allow a certain distance from the easement and the only, for the bill to stop at. But the only exception to that is if you apply with the Water Authority to have that the permission to otherwise build closer to the easement. And again, you've got to weigh up whether it's worth your time,
Exactly.
if the land is suitable for the type of project that you're wanting to pursue. And of course, yes, planning and zoning laws are very important, that any investor, and particularly the savvy ones, will always become familiar with before they even buy a property in that particular locality. So if you're looking at this video and it's your first time wanting to invest in something or to build a project of some sort, that's your starting point, is to look at that planning and zoning and just seeing, are there any overlays that may be preventing me from doing what I want to do? Is this an Aboriginal cultural heritage area where I need to then submit a heritage plan in addition to the standard plans and specifications I ordinarily would need to submit to the council, which, can increase cost. If you're buying a property, for example, if there's a lease agreement attached to the contract, we need to, again, look at that and see, is this under a periodic lease whereby our client would then be able to move in from settlement if the vendor gave the required notice period for the tenant to vacate? Or is it a fixed lease that we're looking at where the tenant's got ample time to complete the lease before they're legally required to move out, and that can impact the client's ability to move in. Sometimes investors do that. They move in and they renovate and then they sell. So then that can be an important factor. So we take into account the client's specific needs.
Absolutely.
And we look at that contract, look at those facts, and work out what the advice needs to look like based on that.
The problem with especially many first-time investors is that they get their advice from their friends, colleagues, family members and like.
Yep.
And according to their limited experience, they receive some advice that not might suitable for them. As you mentioned, each property has a different set of legal limitation attached to it, and also according to the investor needs, you as a solicitor can help them to identify whether those legal limitations can prevent them from achieving their goals. So this again shows the importance of engaging an experienced solicitor in the process in the right time, not after finalizing everything, and not too early. So these are the terms that you need to get familiar with: easements, covenants, zoning laws, rate and levies, and things like that, which Melissa fantastically explained to us. So
the onus is on you as the buyer to do it. It's not on me. It's not on Amir if he's helping you out. It's on you. You need to exercise that due diligence. In Victoria, there's a very heavy onus on you to do that for yourself. There's a lot of case law around that. So valid point, Amir.
Just other terms like cooling off, unconditional contract, or subject to finance and subject to pest and building inspection, which are absolutely critical to any successful investing. So just tell us about these terms.
Yes. Sorry, the first one you mentioned was cooling off. So in Victoria specifically, if you buy a property privately, but not within a 3 clear business day window before or after an auction, and not at an auction, provided you meet that qualification, and you buy the property privately, which means it's not in an auction, then, or publicly advertised auction, then you get the benefit of what's called a 3 clear business day cooling off period from the day that you sign, not from the day the vendor signs, from the day that you sign. So if you sign today, you get 3 clear business days from today to be able to end the contract for any reason whatsoever, which is a great right to have, just in case you needed to change your mind and you found another suitable property for you or your investment needs, for example. But you just need to know that if you do exercise a cooling off period, a cooling off right, you need to forfeit the hire of 0.2% of the purchase price or $100, whichever is higher between the two. So if you've paid a holding deposit and then you change your mind under the cooling off provision, then it does in fact entitle the vendor to retain that holding deposit if it meets 0.2%, for example, of the purchase price.
It was a very interesting point that you mentioned. You said 3 days after the buyer signed the contract, not the vendor. So
3 business days.
It is very important because some agents or some vendors are not that quick to act. So you sign a contract and it takes a week or 4 days or 5 days to them to sign the contract. So in this case, basically, we don't have a cooling off period. Am I correct?
Correct. So agents are fairly crafty in facilitating that at times. So you have, and you may be told by an agent that, look, I mean, there's other offers on this property. You need to sign today, but you do get the benefit of a cooling off period. So if you sign today, you've still got that if you need to change your mind. Unbeknownst to the purchaser, yourself, if you're buying, the agent can or the vendor can wait out that 3-day period before the vendor signs to sell you the property, and by that point in time the contract might be unconditional. So it just emphasizes the point that always get your contract reviewed before you buy. Don't rely on a cooling off period to do that for that reason.
Or another way that we normally do for our clients is to advise them, or basically we are not in a position to give them legal advice. We just tell them that, there is an opportunity to put a clause in the contract when they sign a contract to just say my price is valid until, just 12 hours or 24 hours. In that case, it forces the vendor to act more quickly so that you have that opportunity to basically use that cooling off period if you change your mind at any point of time. Is this something that you think people can use?
They can, provided it's drafted properly to give them the remedy to back out of the contract.
Perfect.
And again, it's important to get a solicitor on board, not just a conveyancer.
Using correct words and
a solicitor.
clauses.
Yes, it's not enough to do a one-liner. I would argue that you do need to have a solicitor to draft that clause for you carefully to ensure it's got the right remedy that gives you that clear right to terminate, because then it could be void for uncertainty if it's just sort of like a one-liner clause, which a lot of agents put in. So that's just something to consider.
The same thing goes with pest and building inspection, which is a very important part of the due diligence after we sign the contract. So if we don't have that clause, which is completely basically created by an experienced legal expert, we put ourselves in a place which we expose ourselves to risk. So just tell us about building and pest inspection, the time frame, and basically why it is important from your point of view.
Yeah, good question. So my recommendation is always if you've got the time to do it, get a building and pest inspection done before you buy. Get that report before you buy, because sometimes that can actually help you bargain on price. And if you are an investor, your aim is to buy at or below market. So if you've got an inspection report, it's got lots of photos about the state of repair of the property, there might be something in there that you can use to bargain on price if there's opportunity to do that. Obviously, you need to consider market conditions and what other offers look like and things like that to be able to secure the property. But that's just one benefit of having it before you buy. But obviously, you want to know what the structural integrity of the property is, assuming you're not wanting to knock it down or anything. But if you're wanting to keep it and rent it out to get, a rental from it, you want to just understand, what it is that you're buying. But in the absence of having any time to do that before you buy, yes, making the contract subject to a building and pest inspection report is beneficial in the sense that it enables you to end the contract within a certain period of time if the building inspection report, for example, shows major structural defects or major pest infestation. As a property lawyer, I definitely look at those clauses in the contracts to see how much is it actually protecting you as a buyer, because I've had scenarios where, I've seen these special conditions that say, the contract's subject to a building inspection report, but it's not subject to a pest inspection report. I had a scenario where a client's gotten the inspection done by the builder. The builder's actually noticed that the property is riddled with termites. The client wanted to get out. The contract didn't give them a remedy to do that. So we got the best outcome for the client, which was great. She was happy in the end, but that's just a scenario of why it's so important that you get a solicitor on board to actually make sure that that clause properly protects you.
Absolutely.
Yeah.
So what is the options if an investor basically engage a pest and building inspector and realize that there is a major leakage, for instance, in a bathroom? Since it is not part of major structural issue, or it is not major infestation of pests, what is the solution here? How can we protect ourselves? Because, you know, inspectors use a certain type of tools to just realize if there is any leakage, which basically normal people cannot do by only inspecting and, you know, just trying to find it themselves. So how can you protect yourself if you sign a contract and then building inspector tell you there is a major leakage in your bathroom, which costs you 20 to 45 or 50 grand if you buy that property?
2 points about that. So the first is just me emphasizing, and that scenario is a classic reason for why it's always better to get an inspection report before you buy. So that's number one. So you just avoid that scenario and hassle of trying to terminate based on what you find out later, trying to terminate the contract you've signed based on what you find out later. But if you do sign and you've got a subject to building and pest inspection clause and there is a leakage, what we do as part of reviewing the contract is we look at those clauses and ask, what can we do with that clause? How can we amend that clause to give you broader rights to be able to back out if you need to? So if you're particularly prudent and concerned that you might find something that might not meet the threshold of being a major structural defect, we might suggest that it say current defect, so that it encapsulates a lot more scenarios that you can rely on to be able to end the contract.
How about a clause like basically that report should be to absolute satisfaction of the buyer, which is a very vague term, and you can, you know, just argue anything with that clause. How legal is that? How useful can it be?
It can be used on a practical level. It can be useful because you as the buyer, you have the control over what the outcome would be if you didn't find something that you liked, if you found something that you didn't like in the report. Whether it has proper legal standing, if it was to be contested, is another thing, because there is case law out there which puts into question whether that clause would have any standing or would be enforceable because it's so subjective.
Absolutely.
On the purchaser. So you know, if it said something that if it was constructed to say, for example, it needs to be to the purchaser's reasonable satisfaction, that's a different scenario, because there's objectivity in that, where you would ask, if it was a question of enforceability about the clause, you would, you know, it's a question of what would a reasonable person do. So it's, again, it goes back to the careful construction of the clause that really matters, because you can't assume that the vendor's solicitor isn't savvy.
Yeah.
You can't assume that.
Perfect points. Perfect points. Thank you, Melissa. So there is a very widespread confusion about several terms: conveyancer, solicitor, and conveyancing lawyer. So just tell us the difference between these terms.
Okay, so lawyer and solicitor is the same thing. It's just different words to describe the same person. So a conveyancer is effectively a professional that is trained and insured to do one thing, which is just the minimum that's required to transfer a property from one person to another. using a conveyancing lawyer or a property lawyer to represent you and do the conveyancing for you means that you have more expertise at hand to deal with more than just the minimum that's required. A lawyer should be the one that's reviewing a contract because they're legally trained, qualified, and insured to represent you legally and to perform that sort of work. If a conveyancer steps outside of scope, they may not be covered under insurance. That's bad news for you because if they do something wrong and they're negligent in some way, the insurance isn't going to help you in terms of compensating you for any loss that you suffer at their hands. Whereas with a solicitor, we're fully trained and qualified to do not just the conveyancing, but to represent you if there's any issues, to prepare contracts. So if you're selling, it's also, we can prepare the contract in the Section 32. We can give you advice along the way. That's very common in transactions. So you can easily see that there's just a lot more bang for your buck when you've got a lawyer involved in your transaction. It's enticing at the beginning to accept a very cheap
A
quote,
couple of
if you
hundreds
like,
of dollars.
with just a conveyancer. But and it looks enticing because you look at the dollar figure, you're like, oh, I'm saving money. But at the same time, what we don't think about in that moment is, well, what if something goes wrong? How is this person going to be able to handle this? Are they legally able to handle this? And if not, what do my legal costs look like?
Absolutely.
Because it needs to be outsourced. And then you think long term and you go, oh, actually, so what? If something goes wrong, I'm paying for this cheap quote, and then I'm paying again for a solicitor because the conveyancer, if they're responsible enough, will tell me that they can't give me the legal advice that I need. It's more stress for you to bounce around between one person and another. So the answer is you just hire a conveyancing lawyer from the beginning, and your problems will be solved.
Absolutely. So what traits should an experienced solicitor have to provide a good value for money?
I think they need to be comprehensive when they're giving you advice about a contract in Section 32. It's not enough to give you a 5-minute conversation. For example, we would send you an email which has comprehensive advice and recommendations and drafting of any clauses we think need to be inserted and why. And the advice needs to be explained in a meaningful way. A lot of lawyers may present information in a way that you might not understand because legal jargon isn't your forte. But we try to explain things in a meaningful way to you so that you don't have really any questions after you've read the advice carefully. So it's about providing a comprehensive service, and that's not just limited to the advice, but that's throughout the transaction through to settlement, where you haven't got someone that's charging you for every phone call or every email that needs to be looked at. Being proactive in the advice that you get. So if you need to have someone that's got quite a good attention to detail to be able to spot issues and raise them with you before you even realize them themselves. Like, for example, it could be something even small. Like I had a client a few months back. I looked at the contract and I saw that their name wasn't correctly recorded in the contract, and something simple like that people don't care about. But then if you're getting finance, your lender's going to care, and it's going to stop your loan application. Absolutely. Which will cause delays. And then if you've got a subject to finance clause in the contract, you might not be able to meet that purely because there was a missing letter in your name. So spotting those things, and in that scenario, the client didn't even realize it themselves. But it's that sort of attention to detail that really matters as well. And I guess someone that you feel comfortable with. So if you are, that sort of person that likes to shop around, it's very important that you speak to the person on the other side to gauge, is this person experienced enough? Do they sound like they got their stuff together? Do they sound helpful? You just need to assess whether they're going to give you the most value for what you're paying. And it's pretty easy to judge someone's character when you've actually had the chance to speak to them. And you just need to work with someone that's fairly personable and patient. I think that's an important quality, because you might have a lot of questions. You need to make sure that your solicitor or conveyancer is available to you and responsive. And when they're responsive, they're happy to explain anything that needs to be explained to you. And they're available to you. So someone you can reach without having to wonder, where is my conveyancer? I can't get a hold of them because they've got 101 other files that they're dealing with. So all those attributes combined make a really strong team for you. And you shouldn't expect anything less from
Absolutely.
conveyancing professional.
So you've been doing this for a long time. What is the biggest mistake that you have seen so far from a buyer point of view, and what were the costs to those mistakes that they could have easily prevented using an experienced person like yourself?
I can come up with, I can not come up, but there is a scenario that's come to mind. I've seen scenarios where conveyances have gone wrong, but if there's a scenario where it's just completely not the desired outcome that the clients wanted, is where I've been asked to review an off the plan contract, and I've got a client that had their loan application underway to get their pre-approval. Luckily, it was just a pre-approval and they hadn't signed at that point, but I'd noticed in the off the plan contract that there was a clause called a buyback clause where, and this is just one of many scenarios where I've seen things go wrong. But we've seen a clause called a buyback clause, which enables a developer to buy back your land, and in most cases, less than the market price than what you pay, less your stamp duty costs, less your title registration fees, and less your legal fees. If you don't meet certain conditions under the contract. So this particular property was an off the plan land lot. And when I say off the plan, I mean an untitled, not yet constructed land lot, where if the client hadn't built the property within a certain period of time and hadn't started construction within a certain period of time, or in some way hadn't complied with any design guidelines, that the developer could simply just buy back the property at the rate that I described earlier, which would have put the client at a significant disadvantage.
Yeah.
In addition to that, the clause had also mentioned that the mortgage contract needed to contain that provision. And I can tell you very confidently that no lender will agree to that. And it will certainly, if the lender is, or if the credit assessor is savvy enough and looked at that contract and saw that clause, if you had bought that land lot and you then tried to get finance later, no lender would actually give you money to buy that land lot, which meant that you would have been stuck in a situation where you couldn't in the contract, and your deposit would have potentially been forfeited to the developer. You wouldn't have been able to get that back. So that was a scenario
no one wants to be in.
No one wants to be in a scenario. So I was able to spot that and advise the client clearly about that, and that had saved our client a lot. It was enough for the client to say, I need to move to another land lot, and they were very appreciative, because had they not engaged me to look at that contract and give them advice, their scenario would have looked very different later on. So
absolutely.
No, there's other scenarios I can give you, but I think it would just take too much time.
This example just shows the importance of your role. So I really appreciate everything that you shared with us today unconditionally. Really important things that every investor need to know. So basically, I think I don't have any other question to ask from you. You explained everything perfectly. Thank you very much, Melissa, for being here today.
You're most welcome. Thank you for having me, Amir. It's been a
My
pleasure.
pleasure. My pleasure. So if you've liked what you've heard today, please like our channel and leave us a comment. And on that note, this episode is a wrap. We'll see you guys again very soon. Bye for now.